it was only a few years ago that the first woman was appointed to the High Court, so that was back in the, I think it was the late 80s. So it's and gradually we're seeing women take a greater role in the judiciary within Australia.
Yeah.
But it's still in terms of their representation in the upper echelons of law firms and at the bar, they're still underrepresented, I think. And there's a lot of work being done on that, and some governments say, one of the state governments, for example, says we look at how the big firms brief women barristers, and say if you want us to brief you, that is the government, then you have to show us that you've got a good record in terms of diversity briefing.
Right. It's actually probably no different than the U.S., where we could have a lot more women. Representation, obviously, both in the judiciary as well as in the law firms. But it's nice to hear that strides are being taken to ensure that
we have some very active women lawyers associations.
Right.
In fact, I had a tax case on the federal court not long before I was appointed, and the question was whether the Victorian Women Lawyers Association was entitled to a deduction for their subscriptions on the basis that it was a charity, that is for the community benefit. And the question was it just like kind of a trade union, or was it for the broad community benefit? And I held that there was a community benefit involved in, and they didn't appeal against that, so the tax commissioner must have agreed.
I think it's great. Yeah. Justice French, it's fascinating in terms of you're all the way on the other side of the world, and here in the U.S. What is the distinct difference that you can actually see between, the Australian legal system and the U.S. legal system?
Well, there are. I mean, we see sort of high-profile differences that are reflected in television programs about the way that courts are conducted, and sometimes the popular vision of what happens in American courts might be formed by that. It would be, I think, quite misleading. Ultimately, we have our origins in a common legal tradition. The US legal system started off with Blackstone and the common law and so forth. We have the same notion of separation of powers, and many of your statutes, your rules of evidence and so forth are similar to those that we have. And we have links between our constitutions. Our constitution was inspired in part by the US Constitution, because there were people involved in the drafting of our constitution who were great admirers of the US system. So we took part of it. We took responsible government, which has our ministers in the parliament, which is not the American system. And we have a popular referendum process for changing the constitution, which differs. But there are a lot of similarities. One point of difference, which is noticeable, is that in a number of your state jurisdictions you have popular election for judges. All our judges are appointed, both in the state and the federal system. And in fact, I was looking with some interest at recent decisions of your Supreme Court, both about restrictions on campaign speech by judges who are candidates for office, and also the question of the impact of campaign financing on recusal issues that might arise later when a contributor is appearing before that same judge.
Right.
Fortunately, those issues don't arise in Australia without the election. In fact, I wrote a paper and gave a speech not long ago in Australia called In Praise of Unelected Judges, because we've been having a debate internally about whether we should have a human rights bill. And the opponents of the bill, and I'm not taking a position on it, but the opponents of the bill say it shifts too much power to unelected judges. Now, I was a bit worried about the notion that this term unelected judges might suggest some sort of democratic illegitimacy, so I was comparing the elected and the unelected systems.
Wow, that's a big difference.
My word.
Yeah, very interesting. You indicated about, mentioned earlier about movies that you've seen, on TV about, the judicial system. You have been cited for giving humorous speeches. For example, you have quoted Homer Simpson.
Yes.
And Sylvester Stallone's, who I love, by the way, character in Judge Dredd. Are you a fan of popular culture? And
well, I don't watch Homer Simpson all the time, but I was doing a talk about declaratory relief, declarations. It was pretty boring, and I was wondering what I could do to make it interesting. Then, one of the things about declarations is they have a huge range of applications in litigation. And it reminded me of what Homer Simpson said about donuts. Is there anything they cannot do? So I applied the same test to Sylvester Stallone. many years ago appeared in a movie called Judge Dredd, and he was a combination of a judge and a policeman, and he rode a levitating Harley Davidson, and he would investigate crime, arrest people, try them and incarcerate them all at the same time. So he was an example of what happens when you don't have separation of powers. So it was a good little point to use to talk about Montesquieu and what he said about separation of powers, and then I flashed up a little thing from Sylvester Stallone saying, "I am the law," and the audience liked it. So I think popular culture can sometimes help you to make a point and get it across in a very pungent, succinct way. Then you go back to the serious stuff.
Right. And I think it's really a very helpful way also because people remember it.
Yes.
Whatever you said using those, they actually stay longer with individuals.
That's right.
You gave a speech entitled Judicial Activism, Mythical Monsters. In that speech you said, and I quote, "At the risk of being denounced as a judicial activist, I observe that judges are required by their office to do things. How do you see the role of judges in their relationship to society?"
Well, there is another difference between the US and Australian systems, and that is that you have a Bill of Rights, and that Bill of Rights can sometimes involve judges in making decisions about individual versus societal rights, and they're very value-laden decisions, and they can sometimes be politically divisive. And that's why I think the dispute or issue about so-called judicial activism and the function of judges is far more acute in the US than it is in Australia. But the role that I see within the Australian context, the core role of the judge in hearing a case is to identify what the relevant law is, to decide what the facts of the case are, and then to apply the law to the facts. Now that sounds very simple. It sounds almost like a kind of algebraic equation. But identifying the law involves choice making, and you can't escape that. When you're interpreting a statute, and a lot of our work today in today's society, both in Australia and the US, involves statutory interpretation. You will have choices of meaning. It's very rare to get a statute which will give you a clear, undisputed, single meaning, especially when it comes to court, because when it comes to court there's usually an argument about it. So there's a kind of law-making function at a low level, interstitial level, involved in that kind of choice. Secondly, in applying the law, you may have to apply very broadly expressed legal standards. There might be reasonableness, there might be good faith, there may be unconscionableness. And again, there's choice making in that, and after a while you build up sort of sub-principles, if you like, within those areas of choice. And sometimes even in fact-finding, you are applying things like legal metaphors. If you're in antitrust law, you might be deciding what is the market. Now that is a judgment call which involves discerning the purpose of the legislation and relating that to the area of activity that's being regulated. So the proposition I put in that paper was, given all this choice making, what's left for a judicial activist to do? And what judicial activism is really about is separate questions about, is a judge going too far into lawmaking? Is a judge reviewing a decision of an executive official, dealing with it on process and law only, or sitting in the seat of the executive impermissibly and substituting his or her own preferences for that of the executive? Those are separate questions which are all legitimate questions, and you get them, they get lost in confusion if you just use this general term activist. Usually it means I don't agree with the judge's decision.
Right. Well, Chief Justice Robert French, thank you so much for taking time to educate us about the legal system in Australia and sharing your experiences with us. I'm Aurora Abella Austriaco, and thank you for watching the Chicago Bar Association's Justice and Law Weekly. Thank you.